everyone. Welcome. We're glad you were able to come and spend the evening with us. We are going to be talking about what is a limited conservatorship. I'm Alyssa DeFilippo, Program Manager at Parents Helping Parents for Connections, California. We are a statewide online resource and information hub for transition to adulthood and adult services. And this evening, we are finishing up in our 5-part series on financial planning. And I can't believe we're already over. But if you're here for the first time, welcome. If you're a repeat viewer, thanks for sticking with us. Our presenters this evening have been with us for the past 4 weeks, and they are from the Special Needs Planning Group in Santa Clara. Ken Prodger is a financial advisor who specializes in helping families plan for the future, including special needs trusts, life care planning, letters of intent, and how to obtain and preserve government benefits. Ken understands that parents of children with special needs often feel overwhelmed with therapy, IEPs, and countless other issues, leaving little time or energy to address financial concerns. And he knows this firsthand, as Ken has a son with special needs. And he also has been a past board chair of Parents Helping Parents. So it's the last time I can say thank you for our service, Ken. Hopefully not the last time. Scott Gill is a seasoned financial advisor with a passion for building long-lasting relationships with his clients. He specializes in providing financial planning services to families with special needs, helping them to achieve their financial goals. He is a member of the Financial Services Institute and brings a wealth of knowledge and experience to his clients. So maybe if we give them lots of love hearts and thumbs up at the end, they'll come back in future semesters and keep sharing their wisdom with us. So without further ado, I'm going to turn it over to one of them, whoever's going to start first. Thanks.
And I'm happy to get it started. Let me share the screen with everyone. Bear with me here, and we will get it set up.
Looking good.
Looking good, looking good. Well, first and foremost, thank you so much for the kind introduction, Alyssa. It's been a pleasure to be here over the past month. I know you expressed we've flown by. We've flown by over the last few weeks, and I know Ken and I can certainly attest to that. It feels like just a couple days ago we were starting with our initial presentation, and now here we are, end of April, May 1st, tomorrow, and we get one more shot, right? Today we're going to be talking about limited conservatorships. And for those that have been able to be with us over the past few weeks, I'm sure this opening slide has become very, very familiar, right? The labyrinth, our 2-tilt axis, where for those that remember this game, we have the marble. The marble starts on one side, and what we're really trying to do is to cautiously, to carefully get from one end to the other, right? And obviously we're trying to miss those potholes that are in between. And so today, what we're going to explore more is how this particular piece of the puzzle of the limited conservatorship fits into one's overall wealth plan, right? And as we go through this presentation, if it's going to work, before we get started, a quick background upon Ken and I. Again, not to belabor the point, but Ken and I are with the Special Needs Planning Group. We're based here in Santa Clara, California. Our office is right across the street from Levi Stadium. Of all the pieces that you see on here, I think the moral of the story is that working with families that have loved ones with special needs is what we do. 80% of our practice are working with families with loved ones with special needs. So this is not just a bullet point that we put on our website. We are fully ingrained in the community, and we're committed to partnering with those families that are looking for very specialized service and support. And so we are fiduciary financial planners. In addition to that, we've received additional education to acquire that chartered special needs consultant certificate, which essentially helps us get ingrained with the subtleties of planning for this particular subset of clientele. Now, with that being said, as Alyssa kindly mentioned, Ken has been a part of Parents Helping Parents for a number of years, not just participating directly with the company on their board of directors, but Ken and I both are part of the Academy of Special Needs Planners. And essentially what that is it's a resource group. It's a resource group of other professionals, not just in California, right? But across the nation that work with the community as well, right? So there may be times when our clients are outside of California, perhaps because they've moved there or they happen to find us through programming that Connections California or PHP in general put on, and they need support. And so whether it is tax professionals, attorneys, or other financial professionals outside of us, we have access to the resources and tools to ensure that loved ones are getting the care and the service that they need. So that takes us back to our planning puzzle, right? So this is another familiar slide that Ken and I have shown. And what we're really trying to show here is that the pieces of the financial plan don't always fit together as cleanly as we would like, okay? So let's take a step back. Let's go back a few weeks for when we started, okay? And let's touch on some of the topics that we've already had the privilege of covering, right? We started by looking at a broad overview, as in what are those 10 steps that go into planning for a loved one with special needs? And from there, we started to get more granular, specifically going into what is a special needs trust, first party and third party, right? What does it mean to have a letter of intent, right? From there, we started to transition into government benefits, right? Entitlement programs or need-based programs. Said another way, what's SSI and what's SSDI? Who's eligible for them? How much might one receive? How do you maintain the benefit moving forward, especially as you get older or as income and assets potentially change as well? After that, we crossed the path and we started looking at CalAble, right? So CalAble is what we explored yesterday, a wonderful financial tool that virtually every family can have available to them to provide flexibility, convenience, tax deferral, some investment flexibility as well. And that leads us to today. And today we're going to be going into the conservatorship piece, specifically the limited conservatorship. And we're going to talk about not only what is it, we're going to talk about when it could make sense. We're going to touch on some of the pieces of what alternatives might be, but we're also going to outline the process, right? And so as we go through these pieces of the puzzle, I think we have to remind you first and foremost that Ken and I, we are not attorneys, okay? So this is not something that we can set up for our clients. We're going to talk a little bit more about how it does get set up, but there's always that disclaimer. We're not tax professionals, as in we don't file tax returns. We're not attorneys, as in we don't actually file legal documents for our clientele either, okay? Now, with that being said, let's dive in. So our first slide here, what is a conservatorship? Okay, well, first and foremost, the thing that we want people to know is that it's something that's actually appointed by the court, okay? So this is not an entitlement program, okay? Just because you feel like your child may need some type of support, some type of help, doesn't mean that you're necessarily going to receive a conservatorship over that individual. And why is that? Well, as the second bullet point says, it's because court-ordered conservatorships, they're actually designed to take rights away from an individual, okay? And so some of the rights that we're talking about here are, well, the ability to make decisions of finance. They could be about ability to make decisions as it pertains to health-related issues as well, okay? Another common theme that comes up is, well, when my child turns 18, well, what happens as it pertains to having dialogue around their IEP if they're still in school, okay? Well, once that child turns 18, in the eyes of California, they're considered a legal adult. And as a legal adult, they no longer have to be supported by their parent, their guardian at that time, okay? So at the end of the day, when you're looking at the conservatorships, the courts are looking to use them sparingly, right? They're not just looking to hand them out, okay? And so what you're really trying to do is you're trying to find the most least restrictive type of assistance to help a person with a developmental disability to lead the best possible life of their choice, right? And so when we're filing and when we're looking to apply for a conservatorship, that's what we're looking to prove. Is this individual able to make those decisions on their own independently? And if not, how are you, the conservator, able to help them do that, okay? So determining if it's going to be appropriate, or not. Okay, so we touched on a couple of these pieces already. Okay, so the first part is a judge is going to decide whether or not a person with a developmental disability needs the actual conservatorship. If the judge has decided that they need to do so, okay, then they're going to consider who are going to be the area to help them in what are 7 areas. We'll touch on these 7 areas a little bit later on, right? Because the idea of a limited conservatorship means, for the most part, you are not getting access or granted full power over all 7, right? It may be 2, it may be 4, right? It commonly is going to be 5. And we'll touch on some of those areas that may be a little bit harder to get, especially in Santa Clara County, and what we've actually seen up in San Mateo County as well. Okay, so when we're looking at a young adult with a developmental disability, okay, when we're talking about needing help making decisions or help transitioning to living independently, let's talk about what does that actually mean, right? This idea to make decisions. Well, what type of decision? What are some examples of that? Well, if we go on and we actually look, okay, the state of California, they outline for you on their website when you start researching limited conservatorships, okay, what are some of the areas that someone might need help with? The first one, self-care. So what does self-care mean? That means eating, it means drinking, bathing, dressing, toileting, okay? Receptive and expressive language is going to be another one, as in hearing, reading, understanding, speaking, right? Mobility, right? Can they take public transportation? Are they able to walk independently on their own? Riding a bike, driving a car, right? What is their capacity for independent living? I.e., can they live by themselves and not harm themselves, right? Can they not set the house on fire because they accidentally turn the range on and then they go to another room and they forget that it's been sitting on for potentially hours at a time? Are they able to pay their own bills? Are they able to shop for themselves? These are some of the things that the court is looking for, right? As in, we are needing to show that our loved one is incapable of providing this for themselves. Okay, so when we're looking at this transition point, so age 18 is the earliest that one may be conserved. Okay, so how long does it typically take? Let's say we were going through the process and we were looking to set up a conservatorship. What should we be considering as a timeline? Okay, well, ideally you want to be looking 3 to 6 months in advance, right? Between gathering documents, filling out forms, right? Coordinating with regional centers, right? There's an interview process, let alone going to the court. It's not something that immediately happens overnight, okay? Now, even if your loved one turns 18, okay, that doesn't mean that it's a hard stop in terms of you're not able to receive or to gain access to a conservatorship, right? It is something that you could take part in and participate in later on down the road, or I should say apply for, okay? But in many cases, especially for those that might still be in school, they do have those IEP meetings that are coming up, or perhaps those that need more specialized care from their primary care physicians, right? Getting it started sooner than later could be a benefit, right? So as we move forward, okay, some might be thinking, well, what are the rights of the conservatee, right? So conservator, right, that's going to be the individual that's looking out for and acting in the best interest of the conservatee, okay? So the conservatee still has rights, okay? And what are some of the rights? Well, we have them listed here on the screen. Now, some of the things that I think we need to be aware of when you do set up a conservatorship is just because it's set up doesn't necessarily mean that that is set in stone indefinitely, okay? So I point your eyes down here to these final 2 bullet points. A conservatee actually has the ability to request 1, a new conservator, or 2, for the conservatorship to end, okay? So just because we have it today doesn't necessarily mean that we have it tomorrow. And I think part of that thinking is along the lines of, well, if the role of the conservator is to help this individual live their best life and to become more independent, there needs to be checks and balances. Because at the end of the day, we are removing rights of an individual and we're acting on their behalf. At some point in time, will that individual be able to receive those rights and have them and be able to live the best version of their self as independently as possible? Okay, so having regular reviews, which could be every few years, could be a part of that program. Okay. Now, some other rights that you're going to be on here as well. They do have the ability to control salary. They can make or change amendments to a will, right, as part of an estate plan for those that have them set up too. Okay. And one of the things to be forewarned about when going through this process, if you've not already done that before, the ability for them to actually be represented by an attorney during the hearing itself. Okay. So, conservatorship of the estate. Now, there are two types of conservatorships that we're gonna discuss. There's the estate, and then there's the person. Okay. So when we're talking about the estate, what does it actually mean? Well, we're referring primarily to the financial side. Okay. We're referring to being able to help pay the bills, to help oversee existing wealth that someone might have, to oversee wealth perhaps that they've inherited as well, that perhaps can go into a special needs trust. So when we go back and we look actually at the state of California on their website, there are three general categories that people fall into when it comes to being conserved for their estate. Okay. Option number one, well, the person doesn't have an estate. Okay. So who might that be? Who might that represent? Well, if the person has a disability and they're only receiving public benefits as an income, like SSI, okay, they don't own any assets, right? They don't own the home where they live. The court may not consider them to actually have an estate. Okay, so what might be that alternative? Well, we outlined it here. That might be where there's a representative payee. Right, a representative payee helps make sure that the SSI is being used appropriately for the expenses for that individual. Okay. Second option, what happens if there's a small estate? Okay, well, a small estate essentially is having no more than $15,000 in assets. Okay, now a caveat, and this is not counting a home. Okay, so they're not getting any more than $2,000 in income, less than $15,000. They could qualify for something that's called a conservatorship of the estate. Okay, one of the benefits of this type of conservatorship versus someone that has a larger estate is you may not have to do annual accountings, right? So less record keeping. Now, the person that has an estate larger than $15,000 or they're getting income above and beyond $2,000, okay, who might that be? Well, perfect example is someone perhaps that received money from a lawsuit, and that money is going into a first-party special needs trust, like a settlement. Okay, or they could have inherited assets that did not flow into a third-party special needs trust. Okay, so that's where the conservator of the estate might be able to become more useful and helpful for something like that. Now, in those particular cases, and when it comes to setting up a conservatorship of the estate or even of the person, it can be very helpful to be meeting with an attorney that specializes in this area. And more importantly, to meet with an attorney that resides within the county you live in, that is familiar likely with the judges that preside over these hearings too. Okay, it's one thing to establish an estate plan, a special needs trust from an attorney that resides within the state that you live in, but it's another thing when you're going through the conservator process and you're working with an attorney that knows that particular system within that particular county, right? So please keep that in mind. Okay. Now, the last piece that we're going to be looking at over here, and we touched on this a little bit, Tim, before I transition over to you, is going to be looking at that conservatorship of the person. And I think this is more commonly where we see our families come in when they're asking for a conservatorship. Really what they're looking to talk about is the conservatorship of the person. And as we explained before, this is designed for people that have developmental disabilities as well. Okay, they're struggling or may not have the capacity to abide by or to live their best life without additional support, right? As it pertains to living independently. Again, when it comes to transferring, toileting, eating, bathing, being able to communicate effectively as well. Now, getting a conservatorship is not going to be the only option that we have to be able to help out, especially when it comes with medical practitioners, or we talked about schools. Okay. Alternatives to this approach could be setting up powers of attorney, durable powers of attorney, right? Whether it is on the financial side or whether it is healthcare directives, right? Another term for this power of attorney with healthcare is called that advanced healthcare directives as well. So within the confines of working with family members, I think at the end of the day, we have this supported arrangement of people, of potentially family and friends. And if that is going to be considered one of the most least restrictive ways to provide support and guidance for our loved one, the conservatorship is going to be on the other end of this spectrum. Okay. It tends to be a little bit more restricted, and it's going to have the most oversight, again, because of the fact that you are requesting that you take some of the rights away from this individual that is set to be conserved. Okay. Now, I guess with that being said, Ken, I'm going to transition it over to you, and yeah, just let me know if there's anything else I can do to help you out.
Okay. So the big thing with the limited conservatorship is really the court is granting special conservatorship rights to potentially parents or whatever to help the conservatee develop maximum self-reliance and independence. So when we talk about all the different things that, whether it's what services are available, supported decision-making, limited conservatorship, we're doing this all for the benefit of the adult child, for their self-reliance and independence. I like to use this terminology a lot, because when we talk about with parents of where is the child going to live in adulthood, independence is important. Many times parents say, well, gee, my child will live with me till the day I die. That's not really the focus that we want to try and approach, is really what's in the best interest of the child. But because the adult individuals with disabilities, they can do a lot of things on their own. So the judges are really only going to give limited conservatorships to things that the person cannot do on their own without their different help. So when we talk about conservatorships, there's always a spectrum of who is going to be able to be qualified for a limited conservatorship. So there's some that it's very simple. The person has, severe the autism, maybe cannot communicate, does not understand receptive language. That's a pretty easy case to make that they need to be conserved. Where we get into the gray areas is, what if the person is Asperger's or high functioning autism, and they're able to make decisions. We may not agree with all the decisions they make, but they're able to make their decisions. And we're more concerned about them being taken advantage of than really making poor decisions. So there's a whole spectrum of that, and we'll get that into a bit. But as your role of the conservator, your job is to make that adult child, lives a full life, meaning that you're taking care of the food, the clothing, the shelter, the well-being of the individual. That's your role. That's what you're asking the court to be responsible of. I kind of just assume it's kind of like saying, okay, what we're doing is we're extending your parental rights as a right as a parent. When the person is a juvenile, that's your job as a mom or a dad to do that. We're just continuing that. Now they're an adult. You're still going to be taking that role of being the parent. So with that in mind, the courts want to see that the conservator should really know who who the individual is, of what their best interests are. That you have intimate knowledge of the child. So when we talk about certain things of who's going to play what roles in things, you may have somebody that is the trustee of the special needs trust, but you may have somebody else who would be the conservator, because they would have a better hands-on knowledge of the individual. So that brings us to the thing. So, the vast majority of adults that we get limited conservatorship over, who's the conservators? The parents. It's always a good idea, though, that if you have the next generation person that is going to be the conservator, go ahead and get them put on there initially, so they don't have to go through the whole process of going through the court when you pass away, that if there's, let's say, a sibling, go ahead and have the sibling, if they're an adult, to be able to be approved for conservatorship at the same time. That's just a little hint or whatever to help you. It lowers costs and it ensures a smooth transition when you pass away. But the people that are listed as the conservators, they need to know the child. They need to know the different things. So they should be the ones that say, okay, when we talk about letter of intent, they should be very familiar. In fact, they probably should have drafted the letter of intent, so they know exactly what the adult child needs. They should know what programs and services that the individual is receiving, and how to make sure that those continue, for the individual's life. They should be fairly close. Okay, you shouldn't, if you're the conservator, you shouldn't be in Los Angeles and the conservatee is, up in San Francisco. You should be close. You should be there, involved in their daily life. Okay, and you've got to have the time and energy to do it. That's another thing. So sometimes we get elderly parents where they were the conservators for a long time, but they eventually turn it over, even prior to them passing away. They kind of turn those duties and responsibilities maybe over to a sibling or somebody else, because it is a time and energy position that you have to be aware of. So this is the meat and potatoes of what is a limited conservatorship. So in California, a limited conservatorship for developmental disability individuals, there's 7 powers. Now, Scott mentioned, okay, there's 7, but there's really only 5. Basically, these 7 powers are what the judge can grant. In the Bay Area especially, they generally do not grant the control to marry and the control to social and sexual contacts. Those generally are not given. Now, this is all based on different counties and different judges. Santa Clara County basically says they will not give somebody those rights for sexual contacts and marry in a limited conservatorship. We see other limited conservatorships in other counties outside of the Bay Area that they do get those powers. So it's very, very hard to get. So we have to be aware of what you're asking for. And if you're trying to get those things, I would strongly recommend that you would have an attorney. So there, with limited conservatorship, depending upon what powers you're trying to get and the ability of the individual that you're trying to get conserved, you may or may not need an attorney. It's one of those situations that, unfortunately, the more disabled, quote, a person is, the easier it is to get limited conservatorship. The harder it is when they are high functioning, let's say Asperger's or so. We come into that all the time where parents saying, well, I'm trying to do this for the best interest of my child. I know they can do some of these things, but I want to be able to help them. That's not how the court looks at it. As Scott mentioned, the court looks at it that you're taking rights away from an individual. And in our society, that's a fairly high bar for you to be able to cross. So we want to be able to do that. The 7 powers, when we talk about, where are they going to live? You have the right to any records. That's also comes into, let's say they're 18 and they're going into an IEP. Technically you need to have either the legal authority to look at those records or where the child is conserved. And so there's your medical decisions, education decisions. These are all the different areas that you need to have to be able to be an effective, basically an adult parent for that individual. So what is the actual, what happens? So when you, through the whole process, when you notify that you want to have a conservatorship, basically you're going to need a medical report. So a doctor is going to need to fill out some forms saying, okay, that giving the court a picture of who this individual, are they going to be able to attend the hearing? Maybe they physically cannot attend the hearing. How do they process information? Are there any mental health issues, thought disorders? Can they modulate mood and affect? Can they consent to medical treatment? again, some of these things, again, high functioning, your child may be able to do all these things. Okay. And so that makes obtaining the conservatorship a little bit more difficult. So once you have the doctor's information, then we move on. Next step is where the regional center actually does an investigation. So this is, so when you're talking about conservatorship, talk to your caseworker and saying, okay, I'm thinking about conservatorship. Depending upon your regional center and your caseworker, they may or may not recommend conservatorship. I know of several, regional centers that are in the Bay Area where they automatically do not recommend conservatorship. There's other regional centers where they say, hey, we take a neutral view on that. If you want conservatorship, we will do the investigation and we'll just present the facts to that. Remember, if your child is a regional center client and they turn 18, ultimately, and they are not conserved, the regional center has ultimate authority over that individual. And so this is not to scare people or to think, but basically once they're an adult, they would be like under the public guardian, where the regional center would be the ones that if there was any medical decisions to make or whatever, that they would have the authority to do that. It doesn't happen all the time. In fact, it's very, very rare where the regional center would step in and say, well, this is where the child should live, or this is the medical treatment that you should have, or whatever, but it can happen. So just remember, if your loved one is a regional center client and they're over 18 and you don't have conservatorship, then the regional center has that authority. So when you request conservatorship, the regional center will file a report to the court, and they will basically be the investigation to report to the judge of whether they feel that this person qualifies for a limited conservatorship. Take a look at all the things related to what services the person is getting, whether the individual comprehends what's going on, are they agreeable to that if they are verbal. So it's really up to the regional center to file that report, and that 9 times out of 10, whatever that report recommends is what the judge is going to order. So it's very important to have a good relationships with your caseworker and what their ultimate ideas for the best interest of that adult child, of whether conservatorship is appropriate, or there are other things, limited power of attorney, some of those things that you can possibly look at. Okay, so where does all this stuff happen? So we've mentioned that there has to be doctor's report. You have to file paperwork. The regional center does an investigation. So what is it? Goes to probate court. So there's about a $400 and something fee to file the conservatorship. The probate court will charge about $900. That's an older figure, so it may be higher now, to do the investigation. That's really to pay the regional center to do the evaluation, pertinent information. And they will interview you. They will interview other people that have a direct knowledge and impact with the individual to get their idea. The individual will also be represented by an attorney, so their legal rights will be upheld. So they will get a public defender, basically, to understand, okay, what are those rights? You may have somebody who agrees with being conserved. You may have a person that does not want to be conserved. And so the court wants to hear what their input is. And again, it's a check and balance of having the individual disabled adult to have an attorney to make sure that their rights are being upheld. So here's what we mentioned, the legal counsel, that the court will appoint an attorney. They file a report. If the limited conservatorship is approved, then the probate department will oversee the conservatorship. What does that mean? That means in the first year, they will come out and actually talk to you, take a look at what's going on, making sure everything is going well. If that goes well, then they will, every 2 years, they will do that, repeat that process again. So there's always a check and balance on the conservatorship. I believe there's a nominal fee involved as well. I'm not 100% sure on that. But the probate court will be looking at, and so you will have some supervision by the court. Okay, so that's one of the negative things, is that the court will be able to take a look of going out and talking to you, make sure that everything is going appropriately. Again, as a check and balance, because we're taking rights away from an individual. Okay, so that's what I want to do is, hopefully we've got some questions and stuff to be able to do about conservatorship. I want to just emphasize that that from the court's perspective, as a parent ourselves, we're looking at, okay, we're doing this for the best interest of our child, to help our child out. The court is looking at, okay, are we taking rights away from the individual to be able to do that? So that it's a totally different perspective to do that. There's lots of self-help information that's out there on the web. Years ago, PHP did do presentations with legal aid to be able to help fill out the forms. Now you can do that online. Certain counties, you can do it, you can file it all online. Other counties, you have to actually fill out the paperwork. Another question that we get often is, do I need to hire an attorney to do that? It really depends on the individual that you're trying to have conserved. What level of disability do they have? Where I see that the attorneys are used most often and more effectively is when you have high functioning individuals. Some of the lower functioning individuals, it's pretty obvious that conservatorship is really in their best interest, and those really are not challenged much at all.
Oh, and how about this? I think this is a good question to actually end on, since it is 7:29 by the clock on the screen. If I've had a conservatorship for a 40-year-old daughter for years and have not had it reviewed, do I need to be concerned?
No, it's like saying, gee, I haven't been audited by the IRS. Should I be concerned? No, be happy.
I love it. I love it. Great thing to end on. I think we actually got through all the questions, although I still see them coming in, but I'm sorry, we are going to stick to our 7:30 end. And, you know, again, if there were applause to be heard, I'm sure you'd be getting lots of it. We ask that you come in with shorter presentations and leave enough time for Q&A. And you did just that. We're very, very grateful to both of you, Ken and Scott, for the time and effort and care and concern that you've shown our statewide Connections California community.